We encourage the police and the investigators to contact us early on with questions. We enjoy being a part of, learning and making the case with them. We can't tell them whether or not to charge somebody, but we can certainly help them understand, any potential issues that they should overcome, whether they be legal or proof issues, and we can help them understand what elements they need to meet.
And certainly we really would like our law enforcement partners to be present for the MDT staffings, because it does help us to share some information with the team, and also helps us have better communication in case they're not able to reach to us outside of those staffings.
Enforcement investigator is the one who investigates the case and determines whether or not a charge should be made. The investigators in our office are extremely helpful in case preparation on the back end, whether we need to locate witnesses after the fact because some time has passed or their addresses have changed and they haven't been kept up to date. They accompany us when we go out into the community to meet with potential victims or witnesses that may not have been identified earlier on. And then when it comes time for a trial, helping to coordinate and making sure that everyone is there, running rap sheets on any lay witnesses so that we may provide them to the defense. And just to kind of help as a team member, the lawyer who's prosecuting the case.
And certainly our investigators come with a wealth of knowledge. Most of them, if not all of them, were former law enforcement officers that work for different agencies in the area. So they also know those partners, and they bring the knowledge that we might be lacking and help us to also communicate with our law enforcement agencies and the detectives on the cases.
So depending on when the arrest is made, departments are supposed to get us their initial case packet or paperwork within 30 days. From there, we meet with the victims. The case is then later indicted, and we determine if there's other records that are needed, whether it be therapeutic records, school records, and we then assess a case based on strengths and weaknesses, both legal and proof-based. And reach out to the defense to determine what, a resolution may look like. Their client may be willing to accept responsibility, resulting in a guilty plea, or their client may be adamant that they want their day in court, and it's going to be a determination of whether or not we can prepare that case for trial.
And to add to that, during that timeline, it's important to know that even though we're working on the case, there might be other hearings that take place, maybe not a plea hearing or a trial, but there could be bond hearings or hearings regarding release of records. So there might be things happening other than a plea hearing or a trial.
We have an ethical obligation within the professional rules of conduct to turn over information. And so while we do our best to redact things that aren't an element of the crime or may have some other privacy implications. For example, pictures from the same exam we do not release. But there are things that we have to turn over, and it's more often than not most of the file. However, if there's something that's questionable, we'll often reach out to the defense attorney and say, for whatever reason this is questionable, but you are welcome to come to our office and view it. But there are just rules that prohibit us from withholding that information and violating that rule of professional conduct. I typically will tell the victims and their families, if you have a question or you have a concern and you're not hearing from me, it doesn't mean that I'm not working. It just may mean that there's not something to update because we're in the middle of reviewing records or preparing for something. And so just keeping in touch, keeping the contact information up to date, whenever, I'm always willing to fill in a victim. We get like what's going on with the case. Can I get an update? All they have to do is ask if we haven't reached out recently.
And every case is assigned a victim advocate in our office, just like law enforcement agencies have victim advocate. Once the case comes to us, there's a victim advocate assigned. So the victim should have the contact information for the victim advocate, but also for us. If there's any other MDT partner, communicate with our office, and they should have our office number, direct line, as well as our email address. In court, so emails sometimes is the best.
We'll get questions about is that a slam dunk. Well, there's a confession, or perhaps the confession doesn't quite line up with other evidence, or sometimes cases can take longer because after the MDT meeting and after that initial something comes up maybe that wasn't brought up before, kind of opens a Pandora's box into something else. And so while all the cases may appear somewhat similar on the change the way things are handled, because a case carries 0 to 20 years, doesn't mean that every single person maybe a reason, whether it's a prison, that because of that you're willing to offer a lower amount despite the egregious behavior. It just, each case is really unique, and there's not a one size fits all timeline or resolution just because the title of the crime is the same.